All righty. Hello, everyone. My name is Victoria Rodriguez. I'm the Executive Director of the HCA, the SA. On with me is my Assistant Director, Tracy Burns. I did want to acknowledge one of our board members who's attending today, Chris Falat. He's with Falat General Contractors, a relatively new GC. He has a lot of previous experience, but went out on his own. So I think this is going to be very timely and exciting for him to hear about. I also want to take a moment and thank our corporate sponsors. At the platinum level, we have HEB, Via Metropolitan, Turner Construction, Central Builders Incorporated, Equipment Share, and Pro Landscape Solutions. At our silver level, we have Bartlett Cock, CPS Energy, JSR Incorporated, Robinson General Contractors, Skanska USA, and Joris General Contractors. At our bronze level, Zachary Construction, Weber, RDR Flooring Services, Vaughn Construction, Frost Bank, D. Wilson Construction Company, The Blue Book, and Dawson Electric. Thank you so much, sponsors, for your support of our association. We definitely appreciate that and know that we wouldn't be here without that type of support. So to get us started, I'd like to introduce Lee Leppert. She's the Senior Creative Manager for the Cromeens Law Firm. Welcome, Lee, and I'll hand it over to you.
Thank you so much, Victoria. I appreciate it.
Oh, Lee, can I recognize one? Sorry, I just want to make sure I don't miss this. Estela Garcia Perez, she's with Fairway Landscape and Nursery. She's one of our board members, long serving. Just want to make sure and acknowledge her. Sorry, go ahead, dear.
No problem. Thank you so much. As mentioned, I'm Lee Leppert. I'm the Senior Creative Manager here at the Cromeens Law Firm. I hope you're all doing well today. Thank you so much for joining us for our Bid and Scope webinar. I'm very excited today. It's been a really hustle and bustle day here at the office. We have Miss Karalynn Cromeens. As of today, she is actually a published author. So I wanted to give a shout out to her on this very exciting day. We're absolutely thrilled to announce that her book, Quit Getting Screwed, is officially available for purchase on Amazon. So congratulations, Karalynn.
Thank you so much.
And during this webinar, Karalynn will go over all the details of the bid and scope of work. She'll teach you best practices regarding these key items, what you need to look out for, and any steps you need to take in negotiating after the contract has been rewarded, and the ramifications of not fully understanding what you were agreeing to. And if you're interested in learning more information on everything that you need to know about the subcontract, there are 20 chapters in this book that go over the subcontract. And actually the Kindle version is on sale today for 99 cents. So in honor of launch day and launch week, we wanted to do a drawing with all of you today. If you would like to win a chance for a free signed copy of Quit Getting Screwed, please submit your first and last name and your contact information in the chat, and we will be reaching out. We'll be doing a drawing this afternoon, and we'll be reaching out in the next several days to announce who gets the free copy. Please note that we do have a Q&A portion after the presentation, so you'll be able to ask any and all questions to Karalynn. You could submit those in the chat. And everyone who has just signed on, I did submit a link to the handout. It's a fill-in-the-blank handout that you'll be able to access and go through as we go through the presentation. All right, so without further ado, I'm gonna let Karalynn take it away.
Hey guys, good afternoon. I wanted to touch, before we jump right into this, on the book, Quit Getting Screwed, and how that relates to this. Quit Getting Screwed is a book about how to negotiate the subcontract. And I wrote it from the perspective of a lot of my clients that got screwed by signing bad subcontracts. I mean, to the extent that they went out of business. And so what the book does, and the book has in-depth chapters on both bid and scope, but it has other dangerous provisions in there as well. I think we need to open up the conversation about, let's have a subcontract that everybody can understand. The expectations are clear on both sides, and nobody has to be afraid of what's in a subcontract because they can understand it. And so with that, I think one of the biggest things there is a misconception on is the difference between bid and scope. They're two separate things. Don't get me wrong, the scope starts with an accurate bid, which the scope is probably one of the most important parts of the subcontract. And the difference between the bid and scope we'll dive into here. There we go. All right, the scope first begins with your bid. The one thing what the bid is, it's a legal offer to do the work referenced in the bid. And so the biggest thing here is do an itemized bid. Say I'm going to do XYZ work, list the square footage, very specifically what you're agreeing to do for a price. There is a free form at the Subcontractor Institute under free resources if you don't have an itemized bid form. What you don't want to do is say, hey, I'm going to do everything in this AC scope for a flat price. Because if you miss something, you're now on the hook to do whatever's in there for a flat price. As where if you itemize your bid, that you're not saying I'm going to do all that work. You're saying I'm going to do this work. So knowing what, to do an itemized bid and the importance of doing an accurate bid is far reaching. Can you go to the next slide? Some other things that I wanted to bring up when doing a bid, you need to look at all of the documents. The potential subcontract, the specs, the plans, obviously, the project manual if they have one at the time, any requests for information. Make sure you have everything that you need before you put your bid together. Okay, yay, your bid was accepted. We're at the next phase. What happens next? You get a subcontract to sign, and the subcontract has a scope. And the first thing everybody assumes is that, oh, I'm hired to do what's in my bid, so the scope is going to match my bid. That is rarely the case. For example, I had one client that installed doors. That's what he did. And then on this particular project, it was a glass door that had an automatic opener. The GC sent him a letter of default because he hadn't installed the electrical components to this door. And he came to my office. I didn't agree to do the electrical. I didn't bid that. And of course, when we looked at the scope, he had signed a contract that the electrical components for this door was in the scope. And so in this case, it cost him $3,000 or $4,000. It wasn't a huge deal, but could you imagine the ramifications of missing something? Don't assume because you haven't done it on this project, it's never been in your scope before, that it couldn't be in your scope on this contract. So the first thing that I tell my clients to do is when you get a scope and a subcontract, review that scope if you were reviewing a new bid and see if it matches your first bid. If it doesn't, then don't sign the subcontract. Send an email and say, hey, this wasn't in the document you sent me to bid. If you would like me to do this work, that's great, but I need the contract price increase, whatever dollar amount. There's also at Subcontractor Institute a free letter, a resource for a free letter that says basically that and asks for a requested increase in the subcontract and the subcontract be reissued. Don't listen to say, oh yeah, we'll deal with that later, because whatever you sign will be used against you. And yeah, you're going to go, well, they told me they would, but they never did. And so make sure that's increased before you sign it. And make sure that you have copies of all of the documents that are referenced in the subcontract. And so that's kind of what we'll go over in the next slide. All right, the first rule about subcontracts is there are no rules. Anyone who thinks that there's a set of rules protecting you, the subcontractor is wrong. They will put in, and attorneys get a bad rap, but sometimes for a good reason. They will put in there whatever they think they can get away with. And so if you just sign it, there's tons of things in the subcontract that you wouldn't agree with. And so to know that going in, that there's nobody looking out for you, that you need to find the tools to do that on your own. And that's kind of what Subcontractor Institute was created for. So you know the phrases to look out for, but just know that you're going to have to look out for your best interest. So you're going to need, the plans, the specifications, look at everything in the subcontract. Okay, the subcontract is the contract between you and the general contractor. All right. You normally in the first or second page of the subcontract is incorporation of the prime contract. What is the prime contract? It's a contract between the owner and general. So what this means is if you don't do anything with it, if you don't negotiate this provision, you're now going to be responsible for the terms of the contract between the owner and the general. Have you ever seen that document? Do you know what it looks like? No, it's not included in the documents you get. So at this point, you need to request a copy of it or ask that it be removed from your subcontract. And generally, if you push this provision, like if you want a copy of GCs don't like to hand out a copy of the prime. So just asking that this be removed or get a copy of it can have great weight. It's really kind of unfair to hold you liable for a contract you've never even seen. So that's normally in the first 2 pages of a subcontract if it's going to be in there. And it's been in 90% of the subcontracts I've read. So know that that's there. Also, you know, it's not just the contract that you're going to be responsible for. It's the plans, the specifications, the project schedule is another huge one. Make sure it's accurate because delay damages are based on that project schedule. Pay applications and lien waivers, normally they have as attachments of what you'll be using. So make sure you review all that and know what it looks like before you sign the subcontract. So like, again, if you find that there's a difference in the subcontract and your scope, make sure to negotiate that. Send over a letter, request an increase in price. Because once you sign it, it's what you're going to be held responsible for, is, you know, as far as even the schedule and everything. And the other thing that I have to point out is that the bid does not become anywhere part of the agreement between you and the general contractor. So if a dispute rises later on, you can't bring it into court to say, this is what I was hired to do. It doesn't even become part of the legal documents between you. And so make sure the scope has everything and you know what's in there. Another important thing is that once you've read it, you've decided on it, you've negotiated, get a copy of the executed contract. It is important. Not to say you can't have claims without it, but it's important for your completed records to have a copy that they've signed and you've signed as well, to make sure that it's an enforceable agreement. All right, the scope that is attached to the contract is what you're hired to do. It can only be changed by written agreement, AKA change orders. So if you are asked to do additional work, you need to get a written change order before you do that work. Not getting a written change order could result in you doing that work for free, because the contract will spell out specifically what is required to get a change order. And so you need to look at this before you sign the subcontract. Some of them have, you know, very onerous terms that say only on Tuesdays at 9 a.m. with this person at this job trailer can you get a change order approved. Obviously, that's not something that's reasonable to agree with. So feel free to change that provision to be like, it can be approved via email. And even if we can't decide on a price, we can decide on a price range. Or I've even seen it where cost plus a certain percentage. So you bring your cost documents and then a certain percentage. But most subcontracts have, if you don't give them a price within a certain amount of days, you'll be doing it for free. Change orders are huge, because you're only entitled to be paid for the work outside the scope if it's agreed to in writing. So know what that form looks like, know who you have to talk to. If this is something that's extremely hard and the subcontract is written, change it. And then another thing, don't do the work and then ask for a change order later, because then there's no leverage. You've already done it. They're not going to give it to you. You've now just done that work for free. And I know everybody wants to keep the project going and they want to keep the general contractor happy, but working for free and costing your company money is not the way to do that. And they don't expect you to do it. They will try to push you to get you to do it, but they know what the rules are. So it's not your issue they won't sign a change order. You've done everything you can to say, hey, yes, I'm ready to do this work, but I can't not, I have to have a signed change order, because trust me, it will be used against you at the end of the day when you don't have it and you submit it on a pay app and they're like, we never approved this change order. I've seen it happen over and over again. Where are we at? Okay, here we go. So knowing the scope, knowing the change order provisions, everybody's responsible for what's in the contract. And normally, that includes little things like drug test, warranty, everything that's in there that you need to know. Another thing that people take for granted is if your contract requires daily reports, you must submit them, and you need to keep a copy of that. Because here's what happens. All the technicalities of a contract have to be followed. If not, it's considered to be in default. If you're in default, the general contractor doesn't have to pay you. And so the general contractor can say, hey, you haven't submitted your daily reports for the last week, so I'm not going to pay you until you do that. Or there's a whole plethora of things. That's why understanding what you're agreeing to when you sign the subcontract is so important. If you have questions, we can help explain it to you. We can help you negotiate. It's just so essential that we understand. It will help prevent disputes later on. Another thing, if you don't review it, it can lead to expensive litigation. One of the biggest misconceptions I see about a subcontractor that was wronged or somebody that hasn't been paid in full is that I'm going to go to court and I'm going to get justice and I'm going to get everything I deserve. That's not what happens. The best you can hope for in litigation is to break even, and 99% of the time you end up taking a loss. I try to advise my clients to be smart about any project or anything they want to take to litigation. Let's weigh the options. Let's look at the cost, because once you let that cat out of the bag, it's gone down the road and you can't bring it back, and it's expensive and it's painful and it's time consuming. You will spend hours combing through your documents, giving me everything you have. And then the other side will get to ask you leading questions about what those documents mean. And trust me, they can make it seem like a simple email with something way more than what is actually there. So having clarity in the subcontract will prevent those type of disputes. So review all the specs, design books, everything. Make sure it matches your bid. If not, take the steps to increase the price and protect yourself. So I think you need to walk into every subcontract expecting to negotiate. Whether it's over the pay when paid clause, the contract that the GC sends over the first time is, if you sign that, it's like paying sticker price for a brand new car. Nobody does that. Everybody plans to negotiate. They expect you to negotiate. At the very least, take out the prime contract. Look at the scope. Be informed on what's in there. If it's going to cost you money to work, it's not worth it. And I'm not saying this to be mean, and I'm not saying it to be hard on the general contractors. All I'm saying is that there's a middle ground. There's a place where it can be clear. I know what I'm supposed to do. You know what you're supposed to do, and we can meet in the middle. But if you don't ask for it, it's not going to happen. And so just asking for little things like the prime contract to be taken out, understanding the scope, just diving in and not being afraid of it, that's the first step. And the more that we'll do this, the more that everybody will do this, the more traction we can make. I'm trying to think if I miss anything essential. The main thing I'd just like to hit again is that you're not hired to do your bid. You're hired to do what's in the scope and know what's in that, because it's generally the same as what you bid. Generally not the same as what you bid. There's usually something additional in there, or so just being fully informed on all that. And I don't know if we have any questions. I'm here for that. I know it went over that kind of fast.
Thank you, Karalynn. Yes, so we really appreciate your time today and everyone. So if you have any questions for Karalynn, please submit any and all questions in the chat. She will be happy. I'll read them aloud and she'll be happy to answer them for you. Looks like we just got something in. Okay. So can you talk about paid when paid, and can you ask for that portion to be taken out?
Okay, I think it's important that we really talk about, before we get about what the pay when paid clause is. Back in the day, the general contractor, when he hired a subcontractor, agreed to pay the sub no matter what, right? Whether he got paid by the owner or not. The pay when paid clause has really flipped the construction project on its head. It makes the subcontractor the one who finances the project. The subcontractor puts out the labor and the material and then waits to get paid. And what the pay when paid clause says is, oh, sub, you're going to have to wait for some event you have no control over for the owner to pay the general to get paid. In no other industry is payment for your work depending on some interaction that you have no control over. So I think there's definitely room to negotiate the pay when paid clause. And if you come at it from the point, hey, I'm not big enough to finance this project, we need to negotiate this. And at the Subcontractor Institute, I have 3 different ways that you can negotiate a pay when paid clause that helps split the risk. Because what the general contractor is trying to do with the pay when paid clause is mitigate the risk of not being paid from the owner. And I know that that is a risk, but let's split it. You can't put it all on me, subcontractor. You know, I don't have the resources to finance this project for you. And so what I recommend is, and there's some specific language at Subcontractor Institute, I think it's in the free resources as well, is that you add language that says, okay, sub, okay, GC, if you haven't been paid from the owner within 45 days, you will pay me, and it's not my fault, whatever my scope is, it's not my fault you're not getting paid. There's 3 different options. You'll pay me 50% of what I'm owed in 45 days. You'll pay me 100% of what I'm owed in 45 days, or you will pay me to file a lien. Reimburse me to file a lien so I can get paid if you really haven't been paid. Those are some things you can do to split the risk, because the general contractor is not just going to agree to throw it out the window. I know that, but there's got to be something in the middle. Or another one that you could add is that, okay, if you haven't been paid by the owner for 45 days, it's not my fault. I have the right to stop working. Because as they're currently written, the subcontract, you don't have that right. Even though you haven't been paid, you still have to keep working. And you're already financing the project, and now you still have to keep working, otherwise you're in default. So let's add something on there that says, okay, you're not going to pay me, then I get to stop working. Now, there's something else, and this is also under the free resources of Subcontractor Institute, is if you already signed a contract with a pay when paid clause, is that you can get around it. You're supposed to be able to get around it. The law is written is that if you're not the reason that the general contractor is not getting paid, you can send a letter after, I think it's after 30 days of you not being paid, to the general contractor saying, hey, I don't want the pay when paid clause enforced against me. And then they're supposed to pay you. That's great in theory. What actually ends, and sometimes it works, what actually ends up happening is they find a small reason, like, oh, the owner is going to charge us, threatening to charge us delay damages, and you were 2 days late delivering to this project, so that's going to be some of your responsibility. And so then even that out for you to get paid doesn't work, which is why negotiating it on the front end is so important, to give yourself some teeth, because if you just sign it the way it is, then you're just going to eat it and have to keep on working.
Thank you. We have quite a few other questions that just came in. Roxanne just asked, what are your recommendations, Karalynn, in regards to schedule delays due to others, and how to address that so your company is not held responsible for a schedule beyond your control?
Okay, there's 2 things here, is that try to negotiate that, because the current way the subcontracts are written, you're not entitled to anything, even if it's not your fault. So you need to find that provision, and there's some help at the Subcontractor Institute to add in that you're allowed additional days if there's changes that are not due to your fault. The thing that I can recommend that is, if you sign a subcontract already with that provision in there, document the hell out of it. Send emails over and over again. Hey, this is not my fault. This is not my fault. This is not my fault. And so that when it comes, the best I can, when it comes, I have this load of evidence that shows while the project is going on that I was saying this, and either there is a response or there's not a response. Because coming to the end of the project and saying, no, but none of this was my fault. They told me, it won't help. But if I have, email after email saying, hey, I need this extra because of this, and it's not my fault, then that is evidence, and put it in your daily reports. That is evidence of that you're not the one responsible. So that if you wanted to fight it at the end of the day, you could. It's way more credible evidence that it's taken at the time that the project is ongoing.
Thank you. Another question from Maurice. Karalynn, why do you think subcontractors are afraid to ask for all the contract documents from the prime?
Well, I think, it's a balance of they're afraid that if they're labeled a pain in the ass, that they won't get the job the next time. And there's got to be an in-between, because you got to be able to work without worried about risking your business. There's got to be, an open line of communication, a clear expectations. It can't be hidden. What you're supposed to do can't be hidden in a bunch of legalese. And to ask questions to have that clarified is not a bad thing, and what you'll find out is most people that are asking you to sign the contract don't even know themselves. And so, coming at it from the point of, all right, let's play this situation out in real life. Like, what would happen if, and asking those questions so they could see, like, I would never agree to that. And seeing that you're not being unreasonable, but you're not willing to take the risk or to risk everything for something you don't understand. So there's got to be a balance. Like I said before, if it's going to cost you to have a customer, you might as well just stay at home.
Thank you. Christina just said, as a general contractor, we invite our subcontractor and vendors to discuss the scope of work mutually agree upon it. One challenge that they do face is getting the subcontract back in a timely manner in order to execute. Do you have any suggestions for them?
Yeah, and I have a draft of an in plain English contract. The problem is they're afraid of it. They're afraid of it and they don't know what to do. And so eventually they'll either decide I'm just going to take the risk and sign it or not. And so, it's like one of those lagging things. It's a necessary evil to get the job, but you don't really want to do it. And here's the thing, it doesn't have to be that way. Let's negotiate something that is clear. It can be written in plain English. If you come at them with, here's the document, and they can read it and understand it, you'll get it back a lot faster. And having the scope meetings, that's a great idea. Because at the end of the day, all we want to do is have a successful project. And to do that, like Brene Brown says, to be clear is kind. If you hide all of your requirements and legalese, nobody knows what to expect and what to do. And then everybody gets frustrated when they don't perform like they're supposed to, but they couldn't understand what they were supposed to do. And I don't blame them. Those things are not very easy to read. So writing something that's easy for everybody to understand would get a faster return on the subcontract.
Great advice. We have a couple questions about mechanics liens, the purpose, need, importance of one, and then also retainage withheld. I'm sure you can kind of bundle that together.
Know your lien rights. Huge thing, huge leverage. What a lien does is, first off, is takes your debt, the money that you're owed, and makes it secured by the property. Without that, basically you have an unsecured debt. The money you're owed is like a credit card debt. It's just a breach of contract claim. You got to go to court and enforce it, and it's a long, drawn-out process. When you have a lien, it's a piece of paper that's filed in the property records against somebody's property. You now have an interest in that property to the extent of your lien. And now you're not only dealing with the general contractor, you're dealing with their customer. And the lien has so much leverage. You cannot sell the property without taking care of the lien. You can't go from what most construction projects are in construction financing. And at the end of that project, they'll need to go into permanent financing. And so all liens will have to be taken care of before that point. And so it's really, instead of what a lien does, instead of you just asking the subcontractor for the GC for payment, it gives, okay, I'm asking the GC, and now the owner's coming down the GC's, saying, hey, you need to pay the sub. They have a lien. You need to get it taken care of. Now I say that you need to do it right, and you need to do it timely. An invalid lien is a liability. Not only will it cost you the amount that you're owed, if they have to sue you to remove it, they'll have to pay, you might have to pay their attorney's fees and a $10,000 fine. So knowing what's timely is huge, but it is so much leverage. Now, for retainage, I have quite many opinions on retainage. The first is, rarely in business does somebody make more than a 10% profit on a project. So your profit's all in the retainage, or a huge portion of it. So don't just ever walk away. But you got to understand, your leverage will be gone. Your lien leverage will be gone if you don't file a timely lien. So all liens have to be filed, at least in the state of Texas, within 30 days of final completion, which is why you have to hold retainage for that long. Okay, no matter when you did your work, your lien has to be filed by then. If you miss that, your lien is untimely and unenforceable. And so when that happens, everybody's done. If the owner's paid retainage, there's no pressure for them to pay you, right? If the lien timeline is, passed and they've gotten paid retainage, you're done working, they don't need you to work anymore. And so retainage is always a pain in the ass to get. So here's what I recommend. Lien it for retainage when you're done. Build in the price of filing a lien for retainage upon your completion, not the project completion. That way you'll get paid 100% of the time. The owner will make sure you're paid before they pay the general contractor. That's the only way to make sure you're paid retainage. But it's such an important part. And I see subcontractors every day just walking away from it. That's where your profit is, and unfortunately, when the project has come to an end and you've done everything, but you've paid your retainers, the GC doesn't have a reason to just pay you because the lien rights have expired. They don't need you working out there. So it just kind of lingers. And I've seen GCs just keep it and let's see who files a lien. I'm not saying that's the right thing to do. I'm just saying I've seen it. And so, and then even if you do file a lien, they'll be like, let's wait and see how long how hungry they get. But if you file it before the GC gets paid their retainage, you'll get paid from the owner. And so the thing about liens is you can never be too early. You can only be too late. So if you know that there's a problem, address it. And the other thing about liens, I know it sounds aggressive, but here's the thing. If the general contractor hasn't been paid, honestly, from the owner, a letter from you might shake a payment loose for them too. If they have been paid, then they've already spent your money on something else and you need to let the owner know, which is why all these notice requirements are required for liens. So, very important. Another benefit to having a lien is you can really secure all the money you're owed, and it has a lot of leverage.
Perfect, thank you. Another retainage question popped up, and I think you may have already answered this, but should primes release retainage at the end of the entire project or at the end of when the subcontractor has completed his or her portion?
I mean, the legal definition of retainage is 10% of the contract between the owner and the general. Now, obviously the GC, spreads that out to all the subs. So legally, there's no requirement for subs to be held with retainage. So it's going to depend on what your contract says. But normally it's after the final project, because the completion of the entire project, because that's what the GC doesn't get paid their retainage till then. So yeah, it's normally within 30 days. It's a final completion. So make sure you're aware of that when you sign on what the retainage time frame is.
Thank you. Daniel just asked, can subs have a terms and conditions letter upfront bidding stage and also attached with a subcontract that must be signed by both parties?
Yeah, I mean, that's something that they can do that is attached to the bid, but then later incorporated into the contract. Yeah. And here's the thing, guys, they can put whatever they want in a subcontract. You can make whatever agreement you want, but what you sign will be used against you.
Thank you. And Victoria, I, for some reason, cannot access the Q&A portion.
Okay.
So anything that's come through there, I've not been able to monitor it. I keep clicking around.
Can I just make sure before we leave the chat, there's a question from Phil. He says, please relate the importance of choosing a construction lawyer to review your construction contract, not your family lawyer. That's a good point.
It's huge. It's huge because we have experience and know what happens with a bad provision, as opposed to your family lawyer. And honestly, if a general contract lawyer were to read a subcontract, they'd probably just throw it in the trash because nobody would ever sign anything that's so one-sided. But knowing specifically, what's important, the things that you need to look out for, and as it relates to your business and being able to operate successfully, it has to be done by somebody that's familiar with the construction industry. And honestly, guys, you shouldn't have to settle for a lawyer that won't return your phone call. I know us lawyers get a bad rap, but we're not all that way. Having run a small construction, material supply company, and whether or not I got this check was dependent on whether I signed this lien waiver, but I need to know, should I sign it? Should I not sign it? And you need to have that question answered that day. And there's so many questions like that. And so that's what, having had that experience as a business owner, my firm is based on that. You get a 24-hour turnaround on your question because I know how essential it is to run your business. And these are important questions and they need to be answered, and not, oh, when I get around to it. They need to be answered on your time frame. You're the customer. I'm here to service you. I'm here to help you grow your business and run a better subcontracting business.
Awesome. Lee, there are no questions in the Q&A section. It was all in the chat, seems.
All right, perfect. You have any other questions for Karalynn? Looks like there's a couple little notes in here, Karalynn. When you were talking about to be clear is kind, Leslie said, love Renee. So I wanted to.
I know, me too.
And then going back to retainage, Christina said retainage for the GC is tied up to our closeout documentation, therefore supplies allows of your submittal, shop drawings, and documents ASAP.
I agree. And there's some free resources in some contractor institute that what I like to call a warranty transmittal letter. It also has some language in there that says, if you don't object to my work, you're kind of waiving your right to object. So a good thing to pick up there that can protect you later on. I always recommend that you do your shop drawings, all that when you're done, not at the completion of the project. Obviously, it's way easy to remember what you changed or anything like that when you're at the project and shortly thereafter. And another thing, I had to bring it up on warranties, and don't issue a full warranty if you haven't been paid, including retainage, or make that warranty subject to, being paid the full amount. So there's some great free resources about that at Subcontractor Institute too.
Lee, did you see that last comment from Estella? She always has her insurance agent look at the indemnification. It's helped her a lot over the years.
And that's, the indemnification provision. There's some that by operational law can't be enforced against you. Like there are indemnification provisions that say that you're responsible for the general contractor's gross negligence. That means he could basically go do whatever he wants and you do, and that can't be enforced against you. But I always, your insurance agent, making sure you have the required insurance is a huge thing, and workers' comp and all that stuff. And, yes, lots to cover with insurance and indemnity.
And you've kind of mentioned throughout it, the Subcontractor Management Institute. I feel like now I understand more or less, but that is just a nonprofit, Karalynn, that offers free documents for contractors. Is that essentially?
It's both. It's another company that I own that has free documents that are referenced in the book, and also has basically what I've done is from the book, there's 20 chapters. I will teach you the 20 chapters and give you additional resources in each of those if you didn't want to go read the book. But there, there's plenty of free resources, but there are, paid classes.
Awesome.
We actually, that went live as well this week, the site. So I'll be sending out a follow-up email to everyone as well with the link, so you can do some research and see all of the courses Karalynn has provided. They're very important, and we hope you guys check out the site. All right. Do you have any other questions? I think we kind of wrapping up all of the Q&A portion.
Yeah. And I just want to say to you again, Karalynn, congrats on your book, Quit Getting Screwed. I think Brene Brown would really appreciate that title. It sounds like something she would say. But truly, I mean, your time is money, and for you to take the time, not only here on this platform, but it sounds like in your nonprofit offering documents and education, you can tell it's really a life mission to help contractors just understand and do well in their business. I mean, if they do a great job, you'd like to see them come out on top in the end. And I think it's really the way, we're trying to offer information that will get everyone there a lot easier and faster, and then move on to the next project, essentially.
I agree.
So,
And that's the thing, is that they're so good at what they do. And you think when you start, you're working for somebody else, you go start your thing. I'm like, I could do this so much better. And you can, and then you realize there's all these other things that have to be dealt with. And, I want you to give you the keys to do it, or ask for help, and we're here to help. But don't just sign everything.
Yeah, that's the bottom line, right? I think I just want to remind everyone, Lee, about if you haven't already put your name and contact information, they're going to have a drawing. You're going to get a signed copy. Have to go look up that book. And again, we appreciate your time. You are a member of the HCA, and coming again on this platform and offering your talents and knowledge really is what it's about, what being part of this association is about. So we do appreciate you very much. If there's nothing else, Lee, did I leave anything that you wanted to mention?
Just one thing, Roxanne just sent a message. She said, thank you so much for the invaluable information shared, and she already purchased the book. Wonderful. For some reason, the Kindle version is not working. So Roxanne, I'm going to message you right now and get your email address, and I'll get with you on that. I don't know why that's not working right now. So we'll double check for you.
And as a reminder, everyone that registered, so those of you who are here now, you'll get a copy of this video to share. Also those that weren't able to make it, and then it'll live on our website to have as a resource. We will refer to it ourselves. I'm seeing some of our new members. Richie Transport's another new member. So it's exciting. I hope that these types of webinars are helpful. Oh, the name of the book, Phil, is Quit Getting Screwed. Have I said that enough?
And it's on Amazon.
I'm kind of liking it. I don't know.
I know it's brash and everything, but it's not meant to be. It's not meant to be obnoxious. It's meant to draw attention to this very real issue that we need to deal with.
Yeah, I mean, if this type of knowledge can move the needle on our industry of a more fair, dealing, I think the message goes back and forth, right? When subs ask the right questions, then GCs are more ready for those answers. And I think it's just probably projects finishing more timely and without all the hassle on the back end. But I mean, lawyers do get the bad rap. I'd say that you're doing a lot to put them out of that light. We can't thank you enough. I feel like everyone's time today was well spent, and we kept it. We're just under that hour, so that's always important. Anything else, Karalynn or Lee?
No, like I said, I'm here to help you guys. I know you have tough enough jobs. Whatever I can do to help.
Fantastic.
So, good luck out there.
Thank you. Continue doing what you're doing. Lee, we'll be in touch, I'm sure. Hope to see y'all again.
Thank you so much for all the time. We appreciate it.
Thank you, everyone. Enjoy your afternoon, and we will see you next time. Take care. Bye-bye.